Let welcome to Hot Topic Tuesday. And with this one, as we were just having a little discussion here, we are not going to continue on of the lawsuit, the settlements, the decisions, but what we are going to do is just simply take a look at what documents then are we really going to be using now. So you guys that are on are actually getting the first view of the documents that have been turned in to be submitted. So that is what we're going to cover today, is the exclusive right to sell listing agreement and the buyer representation, the contract. So let's go after it. Let me pull them up. You guys should be able to see now the exclusive right to sell, the exclusive listing contract itself. Now I'm going to use the simplicity, but all of us will be using the same document. The only thing that's going to be different is the name that appears on it. This should fit for all 20 locations that we currently have. So as you will see at this point, Midland, this is a benefit for you guys. You're going to have the date that the contract is signed, the date that the listing goes live, and the expiration through 11:59 p.m. Brokerage firm will be right in there. I want to clarify, who is the supervisory broker that we should be putting down? That name is your managing broker. Your manager in your office is who you should put there. Now, I got a feeling in the near future, we're probably going to go back, talk agency again. But for now, understand a supervisory broker is your managing broker, your branch manager. Now, the other thing you're going to notice is this is a lot longer form. Here's the first part that's in this that you haven't had before. It's the year built. So a simple disclosure, seller's putting their name to it. Price terms, all the same. Everything is still included. If there's anything excluded, remember that if it's excluded on here, it's not excluded on the purchase agreement unless it's excluded on the purchase agreement. When we update that, and that will be soon, that will be on there. It'll be a clear statement. So here's the first real key part. Because of what has happened is the compensation paragraph. So if during the term of this listing, anyone produces a buyer ready, willing, and able to buy, to purchase the property at the listed price in terms or for any other price, terms, or exchange to which the seller consents in writing, seller agrees to pay the brokerage firm a fee equal to $395 and a commission equal to blank percent of the purchase price, the sale price. So what is that $395? Well, we used to have as a separate line that said we get to collect 300 or well, 295. We know January 1st, it's now 395. All right. So we're putting it right in there with compensation. Further, if within blank months, now 6 months is what we always put there. It's can be open, you know, we don't want to lose one. So it's a reason it's blank. But within 6 months of expiration, everybody knows the protection period. All right. I'm looking on 2 computers, so I want to make sure everybody's still good. It looks like it. Well, here's the other part. And this is probably the biggest. It is cooperation. So we're now going to Mr. and Mrs. Seller and saying, the brokerage firm, you're going to authorize this, Mr. and Mrs. Seller, to offer cooperation in the amount of to any broker / agent that brings us a buyer. Now, this is no different, but if you take a look at it, it's sub-agent, a buyer's agent, and a transaction coordinator. The guidance that we give everyone is 0 to a sub-agent, 3 and 3. That's our guidance. Why do we say 0 to a sub-agent? Sub-agent is someone that we've never trained, we have no control over, and they're saying as a sub-agent, who do they represent? Who's a sub-agent represent? Seller. And yet we don't have any control over what they say, what they do, how they've been trained. We want to sever. So if you've ever wondered why do we say do 0 for a sub-agent, that's your reason. Why do we then offer 3? Because 3 to a buyer's agent that has severed. If they say something, do something stupid, look, we can always get sued, but we've severed any relationship with what that agent may do. Well, it's the same thing with a transaction coordinator. That transaction coordinator, we have no tie to. So instead of offering 1%, offer the same full compensation you're offering to a buyer's agent. Okay. Now, again, this is set up so that the seller can initial. Now, we're going to guide them. We can guide them, but this is where you're going to have a clear discussion with the seller as to how we're actually using the commission and the compensation that we receive. 4 slots. So yes, Mr. and Mrs. or him, her, or him, her, for yes, and if it's no. So that's the reason for the 4 initial spaces here. All right. Gosh, from there, the only thing you're noticing now basically is this is no longer 1 or 2 pages. It's going to be 3. It's going to cover more, and I'm not covering everything that's added into this, but I want you to notice now that it talks about how we show property, that we can show a buyer whom we represent, all properties, different properties, but it states this. If a particular buyer is represented by the designated agent, we are a designated agency. Therefore, when you are working with a buyer, you've been designated to represent that buyer as a buyer's agent. Designated agent shall notify both seller and buyer, and designated agent shall act as a consensual, disclosed, dual agent of both the seller and the buyer. So guys, don't make any mistake with this. If you represent the buyer, designated to represent the buyer, and you've also been designated to represent the seller, you are a dual agent. But if you do not represent the buyer and you're writing the contract, the purchase agreement, let me put it that way. I do not represent the buyer, but I represent the seller. I am writing the contract with the buyer representing the seller. I am not a dual agent. I don't have a contract. I have not disclosed that I'm the buyer's agent. This says in that scenario, Mr. and Mrs. Seller, you know this is what's going to happen. We have to simply notify them. All right. And then it goes on. And guys, this is the part that we need to describe. This is probably another one of the key changes that you're just going to have to make in regards to your presentation. Designated agent will preserve any confidential information obtained during another agency relationship or in a prior or pending transaction or business relationship. Seller acknowledges and agrees that the preservation of this confidential information shall not constitute a breach of any fiduciary duty owed by the designated agent to the seller. So there's so much more that's now in here that's actually covering us that we haven't had in that shorter form. Wow, we're doing all right because nobody's had any questions so far. Yeah. Okay. I got a question in here, guys.
So don't have to do for an agency relationship like we do now.
I got to do a disclosure of my agency relationship. But that disclosure would be, Mr. and Mrs. Buyer, you're signing here noticing that I represent the seller. So they still sign a disclosure of agency, but a contract would not follow because we do not represent them. Good question. All right. This is just a quick one. Unoccupied or vacant properties. We assume no responsibility for them. Love this because I've had a few times as a manager where a seller thinks it's our responsibility because they're not local for us as the agents take care of the property. It's not. It's still on their shoulders. So it takes that out. We've got the county well septic compliance is in here. That fits the entire company. This is one that somebody said, Darwin, it'd be really nice if we can get this in here. Seller and brokerage firm agree that any and all claims of lawsuits between the parties relating to this agreement must be filed no more than 6 months after the date of the termination of this agreement. So we're trying to limit anybody being able to come back on us. Parties waive any statute of limitations to the contrary. I want everybody to know this. This has been on here forever, but it's common for us as agents, or let me rephrase that. No, it's common for us as agent and almost the entire public to think that they can simply call up and cancel the listing contract. No, they cannot cancel the listing contract. It was entered in mutually, therefore it will be exited mutually. Simply because one party wants out of it doesn't mean we let them go. So always know, just because somebody calls and says, we don't want to work with you anymore. So, I mean, that might be a little bit of my attitude, but we're just going to go, okay. So guys, that is the first one here. Do we have any questions about the exclusive right to sell? What's that? Is there? Oh, there is. I'm sitting here looking, and on this one, it's not popping up. Okay, let me take a look here. Yeah, John, I appreciate that. Actually, by the way, I didn't start with this. I should have. What we did is we actually started with the forms put together by the Michigan Association of Realtors. So it's simply saying our compensation is $395 plus whatever percent of the purchase price. That's our compensation. So it's a single thing. We've never had to explain our fees, our commission, but I've been saying this is a way that we should have been doing this for years, because how can somebody tell you you can't charge $395 plus blank percent of the purchase price when it was a broker compliance fee, a record retention fee, or whatever? There was a lot of mortgage companies even going, yeah, no, you can't charge that. Well, this is just our fee now. So does an agent need his manager's permission to release a listing? Great question, John. Thank you for that one. That's a good point of reiteration. The answer is yes. You always need to have it released. The reality is we've got to go back to the days of pre-license training. And what do we know in pre-license training? What do we learn? Whose listing is it? It is the broker's listing. Therefore, the broker really is the one who has to give the permission to release it. But obviously, we're always going to listen very, very strongly to what you have in regards to that listing staying or going. Let me move over to the buyer representation contract.
I have a question.
Yes,
I was 2 minutes late. So does the 395 show up anywhere else, or is it just there where it says that this is our fee?
that's it. Just like on the other hand, it was in one spot. This is in that one spot.
So it doesn't show up on the exclusive right to sell contract?
That is the exclusive right to sell contract. It
We're
will,
looking right now at the agency disclosure. So I just wanted to be clear. So on the agency disclosure.
it's on the same agreements, will be on all of the same agreements that it currently is. Yeah, so I mean, the first one I showed you was the exclusive listing contract. This one is the exclusive buyer contract. So it is on the exclusive listing agreement. It is on the exclusive buyer agency. It will be on the purchase agreement. And that's just now telling everybody that, hey, there is a fee of $395. So that is going to be just like we had before. All three spots on all three contracts. Yeah. And by the way, yeah, you know, look, just remember January 1st is when that goes up. We hope to have these on all of our, what's the word, document servers. So Transaction Desk, Remind Docs Plus, and all of the others that are out there. So, so buyer agency contract, same thing, supervisory broker, reminder, that is your managing broker. That's a manager within the office. You're going to have, again, the designated agency. First thing that you got that is different, it does talk about, hey, flood insurance. Here's where you can go to be able to get it and find it. But we're now going to limit the scope of our search. My best way of being able to just put what you would put here is to be generally specific. Yes, that's an oxymoron. Be generally specific. You can't be so specific that a buyer, let's say you wrote in here and you got overly specific, that you put a new home in Utica Schools that was 3 bedrooms, 2 baths, and they bought one in Utica Schools, 3 bedroom, 3 bath. You may just have got yourself to where they don't owe you a fee because they didn't buy what was in the terms of the contract. So you might be more to the point of Northwest Macomb Township, something of that nature, residential property. But it limits it so that you're not basically where we always had been before. We were responsible for the entire state of Michigan because we never limited the scope under which we were to search. This is what that is for. So again, be generally specific. Don't be too specific to where you disqualify yourself from being able to collect compensation. Now, compensation itself. We've left on here because some of you, I think, really are confident enough in yourself, in your business, what you do, and what you may spend to help a buyer find a new home, that you may decide that you want to charge a retainer. This would allow you to do that. Darwin, how much will we charge? I don't know. It's not my money. But if I'm going to do a lot of work and I'm going to spend money on behalf of this buyer, I'm confident in what I do. I got lots of buyers I can work with. This will make somebody committed. So what do you want to charge them? It does state the retainer fee shall be applied against any commission owed to the broker. Okay, so there is a credit back to that. Now here's the rest of this in regards to compensation. In the event buyer contracts purchase desired property, buyer will pay broker a fee of $395 and a commission equal to blank % of the purchase price. So it's the same thing. We just put $395 right in there with it. Here's what we are compensated. Commission is due and payable upon closing. Provided, however, that if the transaction is not closed because of any default on the part of the buyer, the commission shall become immediately due and payable. Some of you are starting to get a little worried about this. Well, guys, let me throw something out. I want you to picture your previous agreements. If you, let's say, because I know this happened, some people were putting a 0 for commission. Some people would leave it blank. My question to you, how much were you to receive? Answer, 0. The buyer was responsible for paying you nothing because that's the contract you signed with them. But then I hear this. Well, yeah, but Darwin, we get paid by the listing broker. How much? See, if you were expecting 3 and the listing broker was only offering 2.5, what did we always have to do? What did we always do? We accepted 2.5. Well, remember what we've seen, that it's now been published that a listing broker need not offer any compensation. So now what you may see is 0, 0, 0. You may. I don't think we're going to see much of it, but I think you will see some. If so, who's going to pay you? And if you did it the same way you had done and you put 0 or you left that blank and you go show them a house where the listing broker is not offering compensation, how much do you get paid? 0. So guys, this is what all those wonderful attorneys did for the general public. We're going to collect our fee now. The buyer, and this is what we need to tell them. And you can tell them the story and just say, hey, thank the attorneys who filed this class action lawsuit and did you this favor. I mean, you can have fun with it. Who's the people you're talking with? We have to make the buyer responsible. We always did, but we could downplay it. Now, the buyer is responsible for seeing that we get paid. Commission obligation shall apply to any purchase agreement executed during the term of this agreement. Executed, not closed. Now it's still got to close, but if it was executed, we get paid. Or during any extension of this agreement. Commission obligation will also apply to purchase agreements executed within 6 months after the expiration of the termination of this agreement, if the property was acquired was presented to the buyer during the term of this agreement. You owe us money. That's what it says. No questions. All right. Guys, here's the real clear part, and this is where it will remove most of the burden. Credit. Buyer will receive a credit against any amount owed pursuant to paragraph 5, otherwise the compensation, for any commission paid by or to the broker by the seller or the seller's listing broker. So if I signed for 3, I got 3 from the listing broker, they owe me nothing. If we signed for 3 and the listing broker offered 2, they owe me 1%. If they bought a house where the listing broker offered 0, they owe me 3%. Okay, so keep real clear that yes, thank you, attorneys.
Good.
They've made the buyer fully responsible. And yes, we need to let them know they are responsible for seeing that we get paid. But that's where your services have to be real clear as to how you earn your money. And that's part of the education we'll continue to work on when we move into the first of the year. I got a question here.
Yep.
Yes, kinda.
Yes, but right now people say, okay, if it's 2.5, like we had, let's say, don't worry about the 5%. Okay, with the new contract, will we have that ability to say that, or? will
With the
they
new
have to
this
write-
contract, you can say you owe me 0.5% because I'm only getting 2.5 from.
Darwin, could you repeat the question, please?
Yeah, so guys, here's the question. Thank you, Martha. The question has come up that what if we've got 3 and a listing broker only offers 2.5? Can we waive that like we've always done? Talk to your listing, or let me rephrase that. Talk to your office manager. I'm kind of getting to the mode of where I'm telling you right up front, if it's short, you're going to owe it. Yes, in the
Question.
past, we've had a tendency to just live with what we've received. But that's why I keep saying thank you. Because attorneys, you think that you were saving the general public money. I got a feeling that it might cost them.
Question.
Because now we're going to go after it. Yeah, Tom, go ahead.
What if these companies that are saying 3% and 0? What if they get a double dip? Now they can't collect any money, right?
So if we have both sides of the transaction,
No. These companies that list at 3 and 0. If they themselves get the buyer, they can't get a double dip, right?
I got you, Tom. So you're saying if there's one of those brokers that are out there that we don't know how much they charge the seller, so there's an assumption. We only know what they're offering as compensation. They might have done 6 and offered 0. Now, the likelihood of that happening, I got to think, is pretty slim to none. Either that or they're not living up to what we're really supposed to do based upon this class action lawsuit. That is why this is part of the agreement with a seller is you're going to pay me X amount and you're giving me permission to offer X amount out to anybody that brings a buyer. So we again, really, Tom, we don't know. But if it was on us and we charged the seller 6% and we managed to have both sides, either representing the buyer as a dual agent or representing buyer seller as a dual agent, or just representing the seller, we still get 6% because that's what our exclusive right to sell agreement says. Okay. Was there another question out there, guys?
Yes, there's another question, Darwin.
Yes, go ahead, Lydia.
Somebody wrote a question. I just saw it.
Okay, I'm pulling them up right now. Let's see. We can renegotiate commission with seller. Do you suggest that? So, Alika, if I'm hearing you right, you're going, what if the listing broker only offers, well, here, let's take it to the extreme. We found a listing broker that did the 0. Could the buyer, I'm going to switch your question slightly. Could the buyer, as part of their purchase agreement, put in there that the seller is responsible, pay 3% of the purchase price, getting applied for the buyer's broker's fee? Yes.
Yes.
That answer is a yes. What we cannot do at this point, and I don't know that it would change, we cannot ask the listing broker to pay compensation. And there is a difference between those two. So it's the buyer asking the seller to pay it versus us going and asking the listing broker to change their offer of cooperation / compensation. So can that 3% from the buyer be rolled into the mortgage? I can tell you, talking with one of our mortgage partners, that the mortgage industry is looking at all of the what ifs. What if this goes in a different direction? And there's loads of sellers that are doing 0. How do we handle that if that were a direction this were to go? So they're looking at that, and we'll have to see what the mortgage industry actually does in being able to help if we have that. So if the seller's offering less than 3%, will this encourage a buyer to contact a listing agent to avoid paying their buyer's broker or their buyer's agent? No. And why can they not do that? What have we got signed? We have the buyer agency contract. They can't go somewhere else. They are responsible for paying us. That's what's in the contract. So, and we've talked about, if you've not been with me before, one of the things that we know, we can't wait until we write a purchase agreement to do agency disclosure in an agency contract the way that so many of us have been doing. When we get a buyer prospect, we need to do the same thing that we've done with a seller. Mr. and Mrs. Buyer Prospect, we need to get together. Are you familiar with the techniques that I use to help buyers buy their new properties at the lowest possible price? We need to get together. We need to sell them on our services and the value of that. In which case, they then sign a contract committing themselves to make sure that we get compensated. Okay? Can we ask the seller to pay the purchase agreement for? So again, I'm gonna be very. I want you to hear what I'm saying. We cannot ask the seller. The buyer, as part of their purchase agreement, can ask the seller to pay that compensation. Okay, so it's not us; it's the buyer. The buyer has to do it as part of their agreement. So those are actually good questions, but we've nailed it with that. All right.
Hey,
Again,
Darb.
the key, they're going to credit. Oop, yes, go ahead, Jen.
Hey, just while we're nailing it in there, so specifically, is it in the terms and conditions that you would just write it in? Specifically that it's compensation, not concessions or?
Yeah, as a matter of fact, I would probably put it very specifically. We'll put a clause in there into the clause library, so it's real simple that seller to pay buyer's broker's fee of blank % of the purchase price. Yep. So we'll put it in there. It'll be very clear. Again, I've talked with a lot of different individuals, mortgage industry, a couple of attorneys, and nobody's given me anything different. In reality, we've been able to do that throughout history. We could do that. What I want you to key then is paragraph 6. They will get the credit. It'll show right at the time of closing. And last week, some of you may remember, so I'm going to sketch this out again. In the old days, we used a certain technique to be able to get sellers to realize why they would want to offer a full commission so that we could offer full compensation to a buyer's agent. And what we would do is we'd say, well, here's a house for 4.0, a house for 3.0, a house for 2.5, and this one's at 0. So Mr. and Mrs. Seller, this is the old way that this would have been presented. If you were a starving real estate agent who only makes money when you sell and close on a house with a seller and broker who are willing to compensate, which one of these houses would you try not to sell? And the obvious answer was this one. As a matter of fact, whose house would that be? And if you could sell a house, which one would you try to sell? And they would point this one out. Well, we couldn't do that with buyer agency in reality, because it didn't matter what a seller listing broker was offering because we had a contractual relationship. But now, picture this. If these are going to be published, Zillow, Trulia, Century21.com, ColdWealthBanker.com, and all the other sites, if the offer of compensation is going to be published, which apparently it's going to be in the future, Would a buyer not want to know what the seller is offering? Now, we're not going to go search for properties based upon. Matter of fact, I don't even think we can do that. But is a buyer going to want to know? Yes. So now I can go through the whole thing. Mr. and Mrs. Seller, let's pretend you're the buyer. And you know that you've signed a contract where you owe your buyer, say 3%. And you know that if there's any shortfall being offered by the listing broker or the seller, that you've got to pull that out of your pocket. And you had an opportunity to look at these 4 homes and buy one of them because they're all the same. Which house would you try not, or would you not even look at? I'm going to go with the one where it's 0. This actually applies again, but now it's through the eyes of the buyer because the buyer is responsible for compensating me. Anything that they can get from the seller or the seller's broker is credited toward that amount. This works again. But we've got to switch.
Question.
It's, yep, go ahead, Lydia.
So back to the 3% that the seller is offering, less than 3%. Will this encourage a buyer to contact the listing agent? Let's say that you have a buyer consult and you explain all of this to them and they said, okay, let me think about it. And then they actually start calling listing brokers because they want to deal directly with them.
Do
Isn't
you
this
have a
something that
contract with this buyer?
No, let's say we before they sign the contract, we explain all of this to them about the compensation.
Okay.
And then they said,
So
you know,
my
let me
answer
think
to it,
about it.
Lydia, is this. I don't know what a buyer will do, but I know what I can do to keep them from doing that. Sign a contract. So if I get, I'm going to cop an attitude. You can't get in my car until you've signed a contract. You don't see houses until you sign a contract. Now, I'm
I
not going to
understand
deliver it
that.
quite that way, but that's what I'm saying. That's the switch that I believe that we need to trigger that we haven't had before, because previously we'd go out and we'd show everybody houses. And if you've been in this business forever, guess what? You've been burned. Some of you have been in for a year and you've already been burned. Well, what's the best way now to be able to prevent yourself from getting burned? Sign the contract. Now they're committed. They have to work with you.
So I
Now,
get that.
earn
This
the
is
right
just
for it. So
This is just a suppose. I'm just
Okay.
thinking that until the buyer is really educated, that they're
Yes.
probably going to think, well, you know, let's go try another agent, and they may go to other agents who may tell them something completely different. And then they say, well, that's Century 21 agent who really we are going by the book. They don't know what they're talking about. I'll sign with you because you're telling me that I don't have to pay that commission. Then of course they'll find out differently. So I think I'm still with the question, like, will the buyer?
I would, you know what? The only thing I would tell you, Lydia, is you brought up the same scenario. And that's why I'm saying, could that happen under your scenario? Absolutely. But if you won't sign a contract with me, I don't care. Don't waste my time. It's not a buyer I want to work with. You're right on, Rick. So yeah, I think we've got to adapt that kind of a mindset that if I do all of this stuff for you, and again, if you're guys, if you're an agent that all you've ever done was go show them houses that they found that you sent them through the MLS, maybe they will go somewhere else because they're going, what's the benefit? Why should I work exclusively with you? I'm not, matter of fact, I'm finding all the homes. I'm telling you, if you're one of those, you've got to find out what we really do, what we really should be doing for a buyer. Then you'll sign a contract, because if you're going to send out, say, 240 letters because you've contracted with this buyer that said they want to live in Lake Oakland Woods, so you send out 240 letters, say, hi, I'm working with Mr. Tom and Joni Smith. They're interested in buying a 3-bedroom, 2-story in your neighborhood. If you've had any thought of selling, please call me. Or better yet, actually make it from the third party. Hi, we're Tom and Joni Smith. we're looking for a 3-bedroom home in your area. If you're thinking about selling, would you call our agent, Lydia? Ugh. Guys, there's so many things that we should be doing for buyers that we're not. We need to use this opportunity. I mean, seize the opportunity, not from a point of fear, but from a point of control, that what we're going to be able to do. And by the way, I dropped you one little thing that you could do, and you just spent how much money sending out 240 postcards, 240 letters. How much did that cost you? What if you started boosting or paying for advertising on Facebook, Instagram, Twitter? What about, what's your time worth? Have you ever really told them what it is that you do to help them find a home? If ever before you've not contacted for sale by owners, these contracts now, you should be. And it would be, hi, Mr. and Mrs. Fisbo. No, I understand. I'm not calling you to list your home. You see, I'm working with buyers, Tom and Joni Smith. I actually identified your home that meets their specifications. I'm just curious if you would mind if I show and sell it to them. What? Well, listen, why don't we get together? Guys, real estate is so simple. All we got to do is talk to people. Okay. Let me wrap this up because holy shnikes. So much for a 30-minute. Let me give you the biggest things. This goes into the aspect that we're going to become disclosed dual agents, because it would be when you have the buyer and you take them to the seller whom you already represent. It covers both what happens with the conflict of interest with buyers and the conflict of interest with sellers. As we continue the education on working with buyers, we'll talk more about that in the future, because many of you have never thought about the aspect of that last time you went out for a listing in a competitive situation and you didn't get it. They went with somebody else and you turn around and then you showed that property. Did you have a conflict of interest? We need to disclose that somewhere, somehow. In this case, to the buyer. Well, as you can see, this is now a 3-page agreement, but it's going to be a whole heck of a lot nicer, going to protect you a whole heck of a lot more. So guys, with that, I'm going to officially end it. And then if anybody wants to hang on, we'll do a Q&A. But if you got to run, thank you for your time. We'll call that good. See you next week. By the way, next week's deep dive is with Kevin Whitlock from Tedder Whitlock CPAs. If you're new to the business, you better be on this. If you've been making money, this is a great opportunity for you to be able to find out, what do I do? What can I do to be able to keep more of the money so I don't have to give it to the United States government, doing it legally. So join us next week. That's going to be with Kevin Whitlock, guys. We'll see you next week. And I'm going to hang on now and answer any additional questions that may come in here, guys. Let's see what we got in the chat. Let's see. What happens when a buyer says they're going to cancel their contract with you because of this? They can't. See, it's a bilateral agreement. I got to tell you, I'm not sure if the cancellation is on this one, but yep, there it is. Get this out of the way for the guys here. Come on. This agreement may be canceled, paragraph 20, or revoked only by mutual consent. So just like I was referring to on the exclusive right to sell, no, it took 2 people to enter into it. It takes 2 people or 2 parties to leave it. So nope, they can't just bypass you because they don't like something you did. Now, there's a lot that goes into the consideration of whether or not we may release someone, but we don't have to. You know, fight for what is rightfully yours. So great question there. Great way of looking at the other side. I wouldn't have thought about the buyer completely bypassing to save money. Yeah, absolutely. So in a lease situation, we need to cross out the verbiage. Go away, change. Actually, I think, is it on this one, John, or on the listing? On the listing, it does actually go into the part of Yeah, leasing and optioning, it is on here. It's just this paragraph, well, this agreement shall also apply to situation where buyer wishes to lease or option property. In those situations, the terms used in this agreement shall automatically be changed as appropriate. So the term purchase shall mean lease, rent, or option, and the term seller shall mean lessor. So it's really just saying, whereas before our other agreements were strictly for the aspect of thinking as seller buyer, and we used it for leases, this one is actually going to address that and saying, just so you know, this is what is meant by this if we are talking leasing. If you are leasing, so this was the question here. Great, that's good, Rick. If you're doing a lease, what do you commonly accept for helping someone lease a property? Half the month, right? So that's what you would put up here in regards to your compensation. I think that's one of the things Sherry and I have to make sure that we are able to do, is be able to put that in there somehow. But yeah, you would just put that in here still. So good question for that. Still in compensation, where it's certain percent of the purchase price.
50% of bidding, you have to change it to monthly rent. The monthly lease.
Let me look at that. Let me look at that. It's an interesting thought. Oh,
Can you share
let's make
Darren, can
another
you share that-
page.
Can you share that
Go
thought
ahead,
with
Lydia.
us? Can you share that thought with us? We didn't hear.
Oh, yeah. So right here, what he was asking is, what about in the case of what would you do if you were using this buyer contract for an tenant looking to lease property? And what we know is we take half of the monthly rent, and basically we would do the same thing that we've always done here. And just we need to make sure that when, say, Remind Docs puts it in, that allows us to put 50%. And I'll look to see if there's something else that might be able to. Yeah, there is other conditions. You could put a star here and just put broker's compensation per paragraph 5. We'll take 1/2 of the monthly rent as compensation. And it might be the easy way for us to do it, as few leases as we actually do. So that might be the way in the end that we have to do it. But again, not really a change other than what now, starting with this MAR contract, is allowed, is that they've put this in here. So it actually does define what if it is a lease. So another great question there. Do I have other? Oh yeah, you guys just want to put it in the chat. So let's see. We will end up discussing what the broker compliance fee, or that brokerage fee of $395 will be for leases. That has not been determined, but I can tell you it will be somewhere between $0 and $395. I know that's a smart aleck remark to it, but it is true. It could go away. It could be $395, but we will let you know once that final decision is made for that. Let's see. To the recording. Actually, just guys, if you want to find the recording of this, go to the HRC Agent Development channel. And matter of fact, if you just go to YouTube, matter of fact, I think there's so much content on there now. If you do HRC Agent Development, it'll take you right to our YouTube channel. But HRC Agent Development, and this will be up there. Sherry's pretty awesome. Typically, she gets them up before the end of the day today, but it could be tomorrow. Yep. Yeah, I could see that. And John, my description to him would be simply that This is just saying if it was a lease, this is not a lease, but if they want to cross it out, I'm okay with that. Yeah, absolutely. Let's see. How will this reflect with relocation clients on the 395 since it is not being called a transaction fee? Wow, that's a great question. I'll throw that across Chris on that, John, but I'm going to guess that we would continue to waive the 395 on relocation.
Yes.
Yes. Well, there you have it. He happened to walk in here at the right time. So relocation, we will continue to waive the 395. So that is not going to change at all. Everything will remain the same with that one. Guys, any other questions?
Darwin?
Thank you, Lydia. I appreciate that. Bob?
Yeah, quick question on the chance that the buyer's fee being compensated from a listing broker might be 4%. Our contract here just has a small little space to put in, one digit. And in the past, I've also put in a minimum of 3%, but there's no room to do anything like that. So what do we do?
Here's one that if anyone watched the letter of the law this week, I keep wanting to turn and go, I got you guys on a TV up here. The letter of the law from Mar Legal Hotline actually stated, because it was always a question of mine, Bob, from way back in 1995, do we need to state that it is a minimum of? And he said, no, whatever you receive from the listing broker, we are entitled to keep, even if it exceeds the amount that we've contracted for. Now, anybody ever thinks about that and finds that, could we end up in a court and they say, no, that's our money. You should have saved us 1% of the purchase price because you got extra. Yeah, I could see that. But I dare say it's never happened in history. It would have been addressed. So, yeah, Bob, I think based upon what he said this week on letter of the law, we don't have to worry about it receiving more than we've contracted for. We can keep that, is what he said very, very clearly. Great question.
Thank you.
Yeah, absolutely. Guys, you got anything else? Well, listen again next week. We got Kevin. I was looking at Rick. I got Kevin coming in here, CPA. You got those questions. You want to know how to keep more of your money. Bring those questions because Rick does a great job of answering those things on the spot. We will. Well, geez, why did you come in here and look like that? Kevin will be in here to answer all those questions. See you next week before I screw up again. Have a great one, guys. Bye-bye.